Hi, this is Ed Pohl on the road again from our Airstream as we travel across the country. A client of mine was experiencing some difficulty recently. Her accounts receivable were increasing, her cash flow was decreasing, and that comes about as a result of clients increasing the time from the service to the time of their payment. In other words, slow pay. She asked, what could I do to protect myself? And there are a number of suggestions that I have, but one of the first ones might be to somehow collateralize the account receivable. If you're owed, for example, $5,000 from a client, what are you doing to protect your interest in getting the $5,000? Never mind when you're going to get paid, but getting paid at all. It seems to me there are a number of options that you've got. And remember, I'm going to suggest some options, all of which have to be checked against your rules of professional conduct in your particular jurisdiction, because some states allow more flexibility in this regard than other states do. First, get a third party to guarantee the payment of the fee. Whether it be a relative, a friend, or some third party, have that person, that third party, guarantee that your fees will be paid. And I would suggest that you put in a time frame there, not that they be paid at any point, because here you might run afoul of some element of the statute of frauds, or going back to real estate law in law school, the rule against perpetuities, whatever. What you want to do is make sure that there's a time frame. For example, no more than 90 days after the billing date, or no more than 180 days after the billing date, or 60 days after the termination of representation. Whatever the appropriate metric and time frame is for you, put a time certain in there by which that guarantor has to come up to the plate. See if your client can get a letter of credit from his or her bank, or perhaps even from your bank if you can facilitate that connection. Letter of credit is always helpful. And again, put in the specific circumstances under which you are able to call on that letter of credit. Have a third party take responsibility for some of the costs. For example, if your service requires an expert, or requires high volume photocopying done by a third party, make sure that they're the ones that bill your client rather than billing it through you, and then you bill the client, thereby making you responsible for that outside party fee. See if you can get a deed of trust on the family residence or some other property that your client might own independent of the adversary. See if you can get some kind of lien on their stock account or other valuable assets. Again, as I say, make sure that you check with your rules of professional conduct to make sure that you can do that. And of course, the best protection of all is to get paid, or just below the level of getting paid, make sure that you watch your accounts receivable aging, so that your clients do not begin to owe you for 2 and 3 and 5 and 7 months before they make any payment to you. If you watch the aging of your accounts receivable and you see that the client is not paying you promptly, is not paying you regularly, then you need to consider whether you fire the client. And we always hear about the client firing the lawyer. How about, for a change, the lawyer firing the client? I would prefer to do my own pro bono. I would prefer to select my own charity and not have my client select him or herself as the charity of my choice. And the way you approach this is by making sure that your accounts receivable stay under control and are paid promptly and regularly. It's one thing to do some work for a client and fight for their principal, PLE, so long as they're paying you from their principal, PAL. Watch your accounts receivable. That's the best protection you could possibly have. Thanks for joining us today. This is Ed Pohl on the road.